Hello, everyone. Welcome to our fourth episode of the Subrogation at a Glance webinar series. Today's episode focuses on an overview of the legal process, anatomy of a lawsuit, and post-judgment executions that you may see in a subrogation claim. My name is Jamie Hart. I'm a partner with the firm and located in our Cincinnati office. I've been with the firm since March of 2009, and I manage our Kentucky, Indiana, and Southwest Ohio litigation practice.
Hello, my name is Kyle Michael. I'm an associate in the Cincinnati office of Weltman, Weinberg, and Reese. I handle subrogation claims throughout the states of Indiana and Kentucky.
This is sort of an overview of what we're going to talk about today in the webinar. We're going to go through some of the typical pleadings that you will see in a subrogation lawsuit. We're going to talk about the discovery process and what discovery means, especially in a subro situation. Motion practice, what kind of motions you would see, particularly motions for summary judgment. Then we're going to talk about alternative dispute resolution, mediation, arbitration, and how that plays out. And then we're going to talk about trials, how trials are conducted, and then once a judgment is entered, the post-judgment execution process. Kyle and I are licensed each in Kentucky and Ohio, and Kyle has a lot of experience in Indiana. So as we go through this presentation, we will try to highlight or kind of sprinkle in some Kentucky and Indiana specific examples. So you, with each of these, so you kind of see how they do differ from each other. Pleadings. Every lawsuit starts with what's called a complaint. Some states call it a petition, but a complaint is a document that's filed that starts litigation. It sets forth the claim against the defendant or defendants. Most states in the United States deal with notice pleading, which means short, plain statement. The complaint does not have to recite every single fact, but just enough to put the defendant on notice of what the claim, what the facts are that support the claim, and what the claim is. The complaint must be served. Each state also differs with the way that service is perfected. For example, in Kentucky, service must be made personally by handing the complaint to a person. In Ohio, for example, it can be done that way, but also be done by ordinary mail service. And Indiana has a different standard as well. So it's important that you understand what your state's service rules and requirements are. Once a complaint is served upon a defendant, that person has the opportunity to file an answer or in some sort of response to the complaint. Typically, each state has a different timeline for when a complaint or when an answer must be filed. Examples are in Ohio, it's 28 days from the date of service. In Kentucky, it's 20 days. In Indiana is 22 days. And again, each state is different, and it's important that you know the differences in your state. An answer is something that it either admits or denies the allegations of the complaint and sets forth certain affirmative defenses that the defendant is going to plead in the case as to why or why not they're not liable for the relief that the plaintiff requests. In lieu of an answer, a defendant can also file what's called a motion to dismiss. Generally, this is under Rule 12. The federal rules and a lot of other state rules mimic that same rule. But a motion to dismiss is filed by a defendant and they seek to dismiss the claims early in the case. It's a very early, again, it's right when the complaint was filed. And it's generally based upon the allegation that the claim pled does not afford the plaintiff any relief under law. It's a very, very high standard to overcome. All the facts set forth in the complaint must be accepted as true. And the defendant must show that even if you accept all the facts as true, there's no claim under the law that would afford the plaintiff relief. Finally, the motion for more definitive statement. And you may see this a lot in some certain subro cases where a defendant doesn't believe that the complaint sets forth sufficient facts to actually make a answer or to admit or deny a claim. So what will happen is a motion for more definite statement, asking the plaintiff to sort of flush out the claims a little bit more in their complaint, so the defendant has sufficient information to admit or deny whatever the allegations are.
So once an answer or another responsive pleading is filed, typically anyway, the discovery process begins. You don't have to issue or engage in discovery, I guess, but generally speaking, you're wise to do so. Discovery is just a process by which either side can learn what witnesses or evidence or arguments the other side would make if the case were to proceed to trial. There are a number of different methods of discovery. You can ask for whatever you want, I guess, but generally speaking, you're entitled to any relevant non-privileged information. Most common, I think, is probably the different forms of written discovery. For example, interrogatories, which are just written questions, right? From one party to the lawsuit to the other. They're a way to obtain information from the opposing party that might be useful in the lawsuit. The answers to your questions can then be used as evidence at the trial or in a hearing by any party, so long as the court permits them to be. Additionally, you can issue requests for admissions. Requests for admissions allow a party to request that the other party either admit or deny various statements under oath. If the statement is admitted, then that statement is considered to be true for all purposes moving forward. What typically happens if the other party responds to a request for admissions, they will typically deny most of those requests. They might admit them. They might go ahead and say, yep, I was liable for this, or yep, I owe this amount of money. Alternatively, they may not respond at all. If they fail to respond in a certain time frame, typically 30 days, I think that's true across all of our jurisdictions, any admissions or requests for admissions that are not responded to are then deemed admitted. You can later use those deemed admitted responses to support a motion for summary judgment down the line. Finally, as well, you can issue requests for production of documents, requests to inspect property, et cetera, and so on as is necessary. You might want to get a look at the property in a case of property damage or an automobile claim, things like that. You also have the option to depose the other party or various witnesses and so on. Depositions are just out of court statements that are given under oath by any person that's involved in the case, not just parties. These statements that are given at deposition, typically they take the form of an oral examination. Statements that are given can then be used at trial or in preparation for the trial. Depositions take time and they cost money. So as to the other party in the case, you can usually glean that information through written discovery, through interrogatories and requests for production of documents and so on. The advantage that depositions have, though, is you're not limited to just the parties, right? You really, with some exceptions, can only serve interrogatories on the other party to the case. You can depose or try to depose nearly anybody, witnesses, police officers, representatives from insurance companies, and so on. You can subpoena them to appear. They might appear voluntarily. By the way, their testimony that they give the deposition can then be used at trial. Like I said, it is costly. It takes time. Sometimes it can be done via phone or via Zoom, but often what you're doing is you're physically going and conducting an oral examination over the course of many hours. You'll need a court reporter there. You'll need to pay him or her for her time. You'll need to pay for copies of the transcripts thereafter. So if you can obtain that information via written discovery, you probably should do so. It's a little bit more cost effective. Finally, you also have the option to do independent medical examinations. In cases where there are bodily injuries, the party or the parties insured, in case subrogation cases, will have received treatment and then evaluated by their own doctor, but the other party may not accept that evaluation, and they're going to want to have an independent medical examiner do an exam as well. In those cases, the defense is usually going to try to get an examiner who they know does this sort of thing, testifying on behalf of defendants or insurance companies as a significant part of their job. If the defense proposes, position that seems biased or unfair, you can object to that. The court will be able to decide whether or not you're required to see that position. It's not necessarily a bad thing. Often what happens is the independent examiner gives a report that matches what your own doctor came up with as well.
Motion practice. So once you've gone through the pleading and the discovery phase, there are certain motions in a subrogation case that you typically will see. The first is and most common, and this is not just for subrogation cases, but also for just in general in civil, in really any civil case, are motions for summary judgment. Motions for summary judgment are can be filed by either party, whether the plaintiff or the defendant, to decide a case without the need for trial. Generally speaking, what that means is that the movement, the person who's filing the motion, must show that there's no genuine issue of material fact remaining in the case that would afford either the plaintiff the relief they seek, or the defendant, or would assist the defendant in the defense that they have claimed. There must be, it's very clear, there must be no factual dispute according to reasonable minds. And again, each state has their own standards. For example, in Ohio, it's no genuine issue of material fact, and that no reasonable minds could conclude otherwise. Kentucky is a much higher standard for summary judgment, which says that it's called the impossibility standard, which is the movement must show that it would be impossible for the defendant, for example, to prevail in their defense, or for the plaintiff to prevail at trial. It's very high standard, and it's typically and especially in a subrogation case, motions for summary judgment are pretty rare, because generally speaking, especially if you take your general subrogation like auto accident claim, there's clearly going to be some facts that need to be flushed out, and people are going to have different views of the way the facts read and what the facts are, and put those to a jury. And so typically in a subrogation case, a motion for summary judgment is pretty rare. Where you may see them is when there's coverage issues, or for example, no fault. Kentucky no fault, and other states may have similar no fault provisions that may preclude a plaintiff from proceeding against an insured person under certain circumstances. So you may see those, which we won't get into today because there's just a variety. But typically, motions for summary judgment, while you'll see them, they're pretty rare. And again, the reason they come after the discovery process is, generally speaking, you're using a lot of the information that you've gleaned or found out through the discovery process to support your motion for summary judgment. The other motions you'll see a lot in subrogation cases are motions in limine. These are generally filed in advance of a trial, generally after a summary. For example, if a summary judgment motion was filed and denied, and the case is proceeding to trial, you'll see motions in limine. These are motions filed again by either party to exclude evidence at trial. They are sought to exclude evidence that may be prejudicial, evidence that may be hearsay, that's not within an exception, evidence that may be privileged, or evidence that a party feels is irrelevant and again would be prejudicial at trial to produce and disclose to a jury. These motions are very fact intensive, detail, regarding with the case, and set forth for whatever reason why this evidence should not be presented to a jury. And again, motions in limine are typically filed, right before trial, and then, filed before trial and heard at any time, but usually on the eve of trial. So they can be kind of difficult because you may need to know whether your evidence that you're either seeking to admit or seeking to exclude will be allowed based upon the judge's ruling, and that could significantly impact your case and, by consequence, settlement discussions. All right, so you've gone through the discovery process, your motion practice, and your motion for summary judgment has been denied. Your motions in limine have been filed and ruled upon. It is now the day of trial. Trials are trials can be done either by jury or by the bench, meaning the judge acts as not only the judge but the jury and makes factual determinations. In a bench trial, everything here is the same that you see on the slide, with the exception of there's obviously no jury selection. In a jury trial, there is a jury selection, and each jury selection allows each party to question the jury and then pick jurors to serve. Jury selection is very important. It's the first time that they will hear from either party, and so and many will tell you that a lot of trials are won or lost based upon how a jury is selected. Once a jury is selected and impaneled, the next thing that happens is each party gets an opening statement or opening argument. Each party gets generally 15, 20 minutes, something like that, depending in these subrogation cases, more if needed, to set forth an opening argument as to what the case is about from their perspective. Once the opening arguments are over, the plaintiff presents its case in chief. That's where the plaintiff will call its witnesses to present its evidence in support of its claims. At the close of plaintiff's case in chief, the defendant gets to present their case in chief, which is witnesses that they want to call that set forth their defenses in the case. After the defendant has closed, each party has the ability to call witnesses in rebuttal to rebut claims or evidence that was said in the case in chief. Once rebuttal witnesses have been called, the last thing for the parties here is that they get to set forth the closing arguments. Closing arguments is the opportunity for each party to stand before a jury and set forth and make their argument based upon the evidence that was presented at trial, why they are entitled to the relief they seek, or why they are why their defense should prevail here. After the closing arguments are made, the jury is retired to the jury room where they reach a verdict, and that verdict is read. These are civil cases; they are not criminal cases, which means that you don't have to have a unanimous verdict. And the standard in these cases are preponderance of the evidence. The jury really does have a task of weighing a lot of the evidence that's been set forth throughout the trial, and then coming up with their verdict. And then once the verdict is determined, it's read to the court, and the case is at that time at least over.
Overwhelmingly, though, most cases never make it to trial. They will come to some sort of resolution or settlement before that happens. Quite often, these happen informally outside of court entirely. They might happen at settlement conferences in front of the court, or they might happen through mediation. Mediation can occur. The parties might elect to mediate of their own volition. They might request the court appoint a mediator, or the court might require mediation. An awful lot of courts in our jurisdictions, as a matter of course, as soon as a civil case is filed, they will set deadlines for discovery, for dispositive motions, and also a deadline by which mediation needs to occur. A mediator is just a neutral person who helps the parties try to reach some mutually acceptable resolution of the dispute. He doesn't decide the case. He doesn't have any authority to force parties to compromise or to come to any type of agreement. Rather, what he or she does is helps the parties communicate so they can try to settle the dispute themselves. He's going to help both parties understand the strengths and the weaknesses of their respective cases, help them understand the risks of taking the matter to trial, and let them understand that they might not recover as much as they hoped, or they might have to pay more than they had hoped at trial. And thus, it's in their best interest to come to an agreement at mediation. How structured or how informal the mediation might be can vary. Generally speaking, there's an opening statement. There might be a joint discussion, and the parties will go into private rooms or private breakout rooms if it's on Zoom or on the phone. And from that point forward, each party just discusses the matter solely with the mediator, who goes back and forth between the two parties and tries to get the parties to compromise. Whether or not the parties are able to come to an agreement, what usually happens at the end of mediation is that the mediator will file a report with the court that kind of details the outcome of the mediation. If there was a settlement, that report can then serve as a basis to enforce the terms of that settlement. Additionally, the parties might choose to resolve their claims via arbitration. Arbitration is just a method of resolving disputes entirely outside of court. Sometimes in the middle of a lawsuit, a party might elect arbitration. It can also happen before any lawsuit is filed at all. What happens in arbitration is very similar to what happens in court. Parties refer their dispute to an arbitrator who reviews the evidence. He listens to the parties' arguments, and he makes a decision. It's a little less formal than a courtroom hearing or a trial. The rules of evidence don't apply, et cetera, and so on. Most of the time, arbitrations happen because of an arbitration clause in some contract. The parties have agreed ahead of time to resolve any disputes that arise out of that contract through arbitration. Subrogation, I think most often it probably happens when one insurance company is subrogating against another insurance company, where the two companies can't agree who's at fault. They just submit the claim to intercompany arbitration. An arbitration result might be binding or non-binding. In the case of a binding arbitration, the arbitrator's decision is final. It can't be reviewed. It can't be overturned by a court, other than in very limited circumstances. In a non-binding arbitration, however, either party can reject the arbitration award and then demand a trial instead. Parties, I think, typically treat a non-binding arbitration as kind of an independent assessment of the strengths or the weaknesses of their own potential lawsuit, with the aim of sort of encouraging a settlement. So once you have an arbitration award or a judgment, then you have to start collecting on that judgment. Sooner or later, everything turns into collections. So there are a number of tools at your disposal to collect a money award. Some you see here, for example, you have the option to garnish a judgment defendant's wages. How you get there differs across jurisdictions. In Kentucky and Ohio, it's just a matter of filing a garnishment with the court. Indiana requires what we call the proceeding supplemental process, which basically just means you have to go through a series of hearings before you can have a wage garnishment or a bank garnishment or any other type of post-judgment execution awarded to you. To garnish some wages, you just what it sounds like. Some portion of a person's salary is withheld by the employer and sent to you for payment of the debt they're owed subsequent to the judgment. Once the employer is notified of the garnishment order, they're legally obligated to make the appropriate deductions and send it to you. Typically, it's a percentage of what we call disposable income, basically just your total income minus various deductions such as taxes, and so on. You also have the option to garnish a bank account via a bank attachment. If you know that somebody owes you money, and they have a checking or savings account, you can ask the court to use the money in that account to pay towards the judgment. Typically what happens is once you file the attachment, the bank account is frozen, and then you request a garnishment order directing those funds to be paid to you. Same thing applies here, where in Kentucky and Ohio, it's just a matter of making the appropriate filings with the court. In Indiana, you will have to attend a proceeding supplemental hearing before you can have that awarded to you. Additionally, when you have a judgment for money against someone, you may have a judgment lien on any personal property, real estate, vehicles, sort of personal property, and so on. That can allow you to collect cash towards the value of your judgment. If that real estate enters foreclosure, for example, or they try to refinance, or they try to sell the house or the car, or whatever the case may be. The difference here between the different jurisdictions is that in Indiana, the judgment lien is automatic in the county where the judgment was obtained. And you can transfer that around if you find that the defendant has moved elsewhere. In the other states, you do need to file the lien with the appropriate court. You have the option to conduct a debtor's examination. We as a firm have various skip trace efforts where we can kind of determine on our own whether or not somebody has a bank account with money in it, or where they might work, so that we can move forward with bank attachments or wage garnishments. Failing that, however, you do have the option to conduct a debtor's examination. That's a hearing where you'll go to court. The defendant is required to appear and answer questions under oath as to their assets. So if you want to find out where they work, you want to find out where they bank, you want to find out if they own their home or any other property, you can ask them there. Again, that is just a tool at your disposal in Ohio and Kentucky. In Indiana, that is exactly what the proceeding supplemental hearing is. It's basically just a debtor's examination. You can ask them anything and everything. It's sort of like a post-judgment form of discovery. So here you see, kind of generally speaking, some guidelines for how long all of this takes. It varies wildly between jurisdictions, obviously. For example, in Ohio and Kentucky, courts tend to move things along pretty quickly. They want to get you in and out of there probably within about the span of a year. In Indiana, things can kind of move a lot more slowly if you allow them to. Either way, it should take somewhere between 30 and 90 days to properly serve somebody. Obviously, that's dependent on how easy they are to find. If you already have a good address, you can probably have them serve their complaint very quickly. Otherwise, you might spend a lot of time searching. But whenever they're served, from that point forward, they have somewhere between 20 to 30 days, depending on which jurisdiction, to respond to the complaint. If they do not respond to the complaint in that time, you can file your motion for default judgment. And that's the end of the process. At that point, the default judgment would likely be granted, and you can move towards post-judgment execution. If an answer is filed, though, you're probably moving forward with discovery. Again, that can take quite a while. The court might set deadlines. The court might not set deadlines. In that case, discovery doesn't begin or really end until the parties figure it out for themselves. Either way, at the end of discovery, that is where there's usually a dispositive motion deadline. If you file a motion for summary judgment, typically at that point, there'll be somewhere between 7 and 14 days for the other party to respond to it. And thereafter, 7 days after that, for you to respond to their brief in opposition. And thereafter, probably somewhere between 30 and 45 days, we can expect the court to rule on that motion for summary judgment. If summary judgment is not granted in favor of either party, you're probably moving forward with trial. Generally speaking, trial is usually scheduled somewhere between 6 months to a year after the answer is filed. That can be a lot longer. However, it's not uncommon to have trial set a year and a half, 2 years down the line. But generally speaking, you're probably looking at somewhere between, I'd say, 12 to 18 months in any of our jurisdictions from the time you file the complaint until you've reached judgment.
Continuing sort of the timeline discussion, once you obtain a judgment, there is also a timeline for post-judgment executions. Executions will continue until the judgment's paid. But the question always comes up is how long is a judgment good for? And again, that depends on your jurisdiction and where your judgment is entered in. But for example, in Ohio, judgments are good, but they do go dormant after a certain period of time of inactivity. And once they go dormant, I believe it's 5 years after the last execution, you have to revive them. And there's a process of reviving those judgments. But once they go dormant, they cannot be executed on until they are revived. Kentucky, for example, a judgment is good for 15 years after the date of the last execution. So as long as you're filing an execution at least once within that 15 years, a Kentucky judgment can be good in perpetuity until it's paid. But but once you reach that 15 years after the date of last execution, the judgment's deemed expired, void, no longer good, and you cannot revive it. It is done. Indiana, for example, a lien in Indiana is good for 10 years, and then the lien is no longer valid after 10 years from the day the judgment was entered. But the judgment is still typically good and can be continue to be executed on. So again, it does vary. Once a judgment is satisfied or is paid, whether through settled, whether through garnishments, whatever the case may be, you do have to satisfy those judgments by filing a notice of satisfaction in the case, and then release any executions that are pending. That would, whether it's wage garnishments, bank attachments, and especially judgment liens. Once you satisfy the judgment, release the lien. At that point, the case is over. The judgment is no longer valid, no longer subsisting against the defendant, and then the case is truly closed and over. We'd like to, Kyle and I would like to take the opportunity to thank you all for listening to this webinar. I hope that you learned something new. If you have any questions, our information is below, and feel free to reach out to us with any questions. Thank you.